Hi, this is Greg McIntyre at McIntyre Elder Law. This is the Elder Law update, and today we're talking about inheritance on hold, which really we're going to talk about probate. Inheritance on hold. Most Americans don't understand the time, the cost, or the dangers of probate, and it can equal an inheritance on hold in many respects. So there's a lot of aspects from this. I took some of our talk today, inspiration from an article, a USA Today article that came out on July 30th with a similar title. And it had some very interesting statistics. And I wanted to really use that as a premise or, a kind of an outline to talk about the dangers of probate, also the time and cost of probate, and tell you some very interesting statistics. And so we'll lay out the problem and then we'll talk about the solutions, okay? Because there's many solutions to this problem. So time it takes to probate an estate. I have handled thousands of probate estates in my career, and it can take months to handle a probate estate. If you get in the weeds with maybe financial companies that don't want to cooperate in transferring assets, dragging their feet, financial companies that are located maybe out of the country, in Canada, other places, it can just equal a lag time in communication. Also, the court systems are, generally take sometimes months to respond back to or approve certain accountings that are filed in a probate case. All that cumulatively can drag out a probate estate. So, the article highlighted how most Americans really underestimate or do not know the time involved in probate. And then, what is probate? Many times at a seminar, I will have, or when talking with clients, they say, hey, I have a will. I don't have to worry about probate. Actually, your will is really not worth the paper it's written on, for example, until you pass away and it is accepted, submitted to a probate court and accepted in a probate. Probate is the court process and procedure by which a will gains authority and an executor is qualified and given the authority to transfer title to assets. Probate is essentially where a will gains legal authority and an executor is given the right to transfer assets under the rules in your will, under the watchful eye of the court. And probate actually works quite well and has for a long time. But there are potential issues in probate. So we've talked about the time element, that it can take months or years to probate a will. If there are will caveat cases, which is somebody's challenging the will, then it can take longer because there's litigation involved that springs from that probate estate or surrounding that probate estate and that will that's being submitted. There's all kind of controversies that can occur within that process. Cost. Generally, the cost is not necessarily exorbitant as far as a taxation standpoint. North Carolina does not have an estate or death tax. There is a $4 per thousand fee when you close an estate that's attached to the probate estate, but that's really not exorbitant. That's not super high. And then there is generally an attorney fee associated with that. To handle a probate estate, it can cost between 3 and 5% of the total probate assets. That is a general rule of thumb. And that's if you're passing your assets through your will. And then there's the amount. Here's the gravity. There's about $84 trillion that within the next 20 years are going to pass from one generation to the next in the next 20 years. So that is huge. And the state of affairs with estate planning, 20 years ago, 74% of households in America had an estate plan, had a will or trust. Today, Only 64% of Americans have a will or trust. So the people who are taking advantage of estate planning and being able to control how you pass your hard-earned money and property is decreasing. And what you're leaving is you're leaving it for the next generation or the kids to try to clean up that mess. And I come in to help clean up those messes a lot of times. It's a lot easier if you have a well-drafted, straightforward estate plan that holds avoiding taxation, maximizing the distribution to the next generation. We can do that. And there's also avoiding the pitfalls or dangers of probate. So that's what we want to look at when we're doing proper estate planning ahead of time. So pitfalls associated with probate or dangers. The real danger is, we discussed one earlier, which is potential litigation surrounding the will. But the real one we see most of the time is claims that attach to the probate estate, creditor claims and or long-term care benefit claims. Those are actually the biggest, because those endanger, say, the home that's passing title to the deed through the probate estate, through the will. Even without a will, if you choose not to have a will, if you don't have any other mechanism to pass that home, title's going to have to clear through what's similar to probate, which is essentially probate without a will, estate administration. And that passes under what we call the state's will, which is the statutes of intestate succession, which already have laid out how your assets should pass. So I would highly advise, if you want to control how your assets pass, a will or trust, beneficiary designations can handle that. Some spouses that I meet with are shocked that there was no will in place, and shocked to learn that they now own a house or other property, money, retirement assets, along with children. It could be the children from that marriage, or it could be the children from a prior marriage. And this can really complicate and cause controversy within a family. But you can, again, direct how your assets pass and not count on or rely on what we call the state's will. Solutions. There are some straightforward solutions to avoiding the dangers if you have to access a long-term care benefit to pay for assisted living or nursing home care. Let's start with the house. A ladybird deed, an enhanced life estate deed in North Carolina, nicknamed a ladybird deed, can keep the home in your name for the rest of your life, and then automatically, when the last one of you or you and your spouse pass away, pass it directly to your heirs or your children, the people you choose, outside of the probate estate. So it doesn't use the will and probate process. This is important because under the benefits rules for long-term care, for assisted living or nursing home care, ladybird deeds are allowed to be placed on the home, even if it's within that 3-year look-back period for the benefit that pays for assisted living care, or the 5-year look-back period that pays for nursing home care. So a ladybird deed can be placed, even in an emergency, on a home and ensure that it stays in your name and under your control for the rest of your life, the owner's name, and then automatically passes to who the owner chooses to pass it to when they pass away. And that's written in the contract of the deed, and it happens automatically. In North Carolina, you can't go outside of the probate estate to pull in that home if there's a claim, say a long-term care benefits claim, filed in the probate estate. So the house is safe. The house is safe. It immediately protects the house, lets you keep it, and then pass it without a benefits claim attaching or any other creditor claim attaching in probate. The second thing, that's a simple, straightforward way to do it, is trust. Trust have beneficiaries. And a trust is much like my coffee cup, where I've been drinking coffee out of this morning. And the cup is what we create. That's what the attorney creates. A container that can hold the deed to the house, that can hold title to any investment accounts or bank accounts or CDs. Those can be contained within the trust and then passed to beneficiaries. Trusts have beneficiaries. So then the trustee that's in control of the trust when you pass away then gives those assets to the beneficiaries under the direction, your direction, in your trust. They have to play by those rules. And many times that's called trust administration. Many times that's handled by an attorney like myself, who helps the trustee interpret the trust, draft deeds to pass along real property, or transfer assets, deal with the banks, things like that. Trusts have beneficiaries. Beneficiary assets do not pass through probate. There's some tricks, or there's some caveats to trust drafting when it comes to long-term care planning. But the main theme is do estate planning, plan ahead, and you shouldn't have any problems. But a revocable living trust is much different than, say, an irrevocable trust, like a specialized trust we draft called a Medicaid Asset Protection Trust. Because you keep control and you can revoke and amend a revocable living trust, a benefit that pays for assisted living or nursing home care would still deem this as your asset and a collectible asset, the same as something in probate. The key is to have that drafted so that it can be irrevocable, but you can still be the lifetime income beneficiary from the trust assets. And then you also have a third-party beneficiary, which sometimes is a trusted child. A convertible trust we draft starts off revocable because you might want to add beneficiaries, avoid probate, and aren't ready to give up control. And then that can be shifted to irrevocable and activate the Medicaid Asset Protection Trust provisions within that trust, like flipping a switch. All this comes from proper estate planning, and it's actually fairly straightforward when we sit down in a consult and explain that, and then develop a plan and meet back and sign that plan, and then go over the plan when we signed it, talk about funding the trust, and then establish a lifelong relationship with our clients, which is what I value and enjoy. When you're a client of McIntyre Elder Law, our estate planning attorneys offer an annual review for free with you, a checkup, if you will. If your life changes, and it will, if there's any constant that I can guarantee you it will be change, if your life changes, we want your estate plan to change along with it. The next thing that is extremely important in solving the problem of the time, cost, and dangers of probate are powers of attorney, oddly enough. The general, durable power of attorney. That's the financial and legal power of attorney. That's what it is. It handles financial matters and legal matters. You appoint someone during your life because it ceases to have any power after you pass away. So your child, if they're your agent under a general, durable power of attorney, cannot use it after you pass away. But if something happened to me and I was incompetent, incapacitated, I needed nursing home care, then I would want my wife to be able to come in and see one of our attorneys and shore up, clean up any failure to plan to protect our assets. And she would have the power. I would have given her the power to do that while I'm alive in that general, durable power of attorney. She might need to protect assets and qualify me for a benefit to pay for that care instead of spending down all our assets. We have kids. We have 6 of them. One of them is out of college. One of them is in college. Four of them have yet to go to college. So she's got a lot of financial matters to deal with if I were out of commission but alive. And she would need to have the power to be able to handle my financial and legal affairs and to help me. So powers of attorney are extremely important when avoiding probate. We also avoid guardianships with the general durable power of attorney and healthcare power of attorney because we pre-appoint the people that would handle those situations for us. A guardianship, the reason that's important, if you have to go to court and appoint someone to handle my assets if I'm incompetent or incapacitated, then the assets are kind of locked in and headed toward that probate process if I failed to do prior estate planning. So I'm kind of on a one-way street and one-way path toward probate. And if that I need a benefit to pay for long-term care, that could equal losing our house in the end when it goes through probate. So, Michael asked in the comments, at what age should someone start estate planning? It depends on what type of estate planning, in my opinion. If you think about, I have children going off to college, I say 18 to 118 for foundational work, general durable power of attorney, healthcare power of attorney, because I want to be able to swoop in and handle healthcare matters and financial matters and legal matters for my children if, heaven forbid, there should be an accident, illness, injury that takes them out of commission for a while. So they would want to do that instead of leaving that open for guardianships, for the courts to come in or to be forced to go to court to appoint a guardian. And then there's different phases of life, Mike. So, if I'm in my mid-30s to mid-40s, 2 young kids, for example, if that's my situation, then I'm going to want an estate plan, and I'm going to want that plan in the will, for example, and there's separate paperwork that's created too, to designate who the guardian of my children should be, my underage children, because if my wife and I passed away, they would require a legal guardian to be able to make decisions and care for them. I would want to go ahead and appoint who would step in and do that. I would want to make that provision in case something happened to my wife and myself. I would also want to set up a will and or trust to state how my assets would pass to my children. Long-term care is not my main concern at that point, but as I age, it will become more of a issue that's looming, closer and closer, because 70% of people over the age of 65 need some type of long-term care. So as I start thinking about retirement and I go into maybe the next phase of my life, or I go into retirement, then I'm going to want to really make sure I have a plan in place ahead of time so that if that long-term care issue becomes a reality for my wife or myself, we don't endanger everything we've worked for our entire life because of the high cost of long-term care. So I'm going to want to maybe look at using trust planning more, or ladybird deeds on the house, or life estate deeds on the other properties, and putting those in place ahead of time, or using trust to house my assets, maybe a convertible trust, because I'm not ready to give up control yet, but I want to be able to flip the switch to go irrevocable with those assets in that trust and not have them counted for a benefits program that might pay for long-term care. So there's different considerations in different phases of life for estate planning. But, when you're young, I would say it's up to your parents under 18 to plan for you, which would be appointing the guardian that would handle your affairs if they deceased. And then at 18 and beyond, the foundational work to appoint who would handle your affairs if you became incompetent, incapacitated, and avoid court-ordered guardianships. Because if there's an argument in guardianship over who should be the guardian, a lot of times the court will not want to set up the family for contention, and they will want to appoint an attorney as the guardian. And that might not be what you want for your children or what you want for yourself as you age. General durable power of attorney, a healthcare power of attorney can take care of those. Then we want to make sure we take care of those children and make sure we take care of our assets when we're in that phase of life. And then moving into kind of that third phase, the golden years, the sunset era, we want to make sure that we recognize and plan around really probate, and we plan around the high cost of long-term care while minimizing taxation, maximizing your ability to obtain long-term care benefits, and keeping you in control of and protecting your assets. Hey, I'm Greg McIntyre with McIntyre Elder Law. I'm an estate planning and elder law attorney. Always less costly to plan ahead than wait for the emergency crisis situation. I would encourage you to plan ahead and seek professional attorney estate planning counsel in doing so, because it's complicated. And probate's complicated. And avoiding claims is complicated. But not if you do it every day. Okay? If I build a house, I want to go to an architect, engineer, get the plans, hire a builder to do that. I'm probably not going to set out to do that myself. So an estate planning and elder law attorney can really help you. That is what I do for a living and have done for a long time. That's what our attorneys at McIntyre Elder Law do. I would offer a free consult, and you could take to sit down and kind of just talk about, your situation. We identify your goals, what your assets are, who the people in your life are. When you take inventory of those things, really, what you want to do and the best plan starts to build itself. You can take advantage of that free consult by calling 1-888-999-6600, or you can schedule right on my calendar online at mcelderlaw.com/scheduling. That's mcelderlaw.com/scheduling. Hey, this is our Elder Law update. We do it live every Thursday at 10, and we'll be back with another topic next week. Morgan, do we know our topic for next week? Okay.
Let's do your title protection services.
We're going to talk about TPS, title protection services, next week. We're going to talk about how to avoid ever having to worry about whether someone changes title to your real estate or tries to take out a loan and file a deed of trust on a property you own. So these fraudulent things, you'll see those advertised on television all the time. We offer that service. It's called Title Protection Service, and we're going to talk about that next week and the dangers that can occur out there and how we can protect your home and other real estate. Thanks for joining me. See you soon.